See, it's Richard Kelly. How you doing? I hope you're okay. I just basically wanted to um, speak briefly to you. I didn't really want to take up too much of your time. I have emailed Brody Waddle a few months ago. I did have a few exchanges with him in email, but obviously he's got his family to look at when he's at home and he's quite busy. And I know that obviously when you're in your jobs and you've got times for your students and so forth, it's difficult necessarily to fit time in. Um, so basically, what I wanted to say is that I really appreciate these transcriptions that you've done of the House of Lords collection for the petitions, and I've actually found out about them a few months ago, and I've kind of like it, I wanted to go through them all. Um, I wanted to read the whole collection. To be honest, there's 2,500 petitions altogether. I'd like to read all of them. People are using it kind of like a resource, as like with a meta tags and a search box. Just as like a study resource. But I wanted to read all of them. Um, but I finally got around to I basically, to be honest, that website is currently not working. When you type in for search and metadata, at least not on my computer, it's not. It doesn't seem to be working, the search function on it. I don't know if it's an error or if it's my computer, but it doesn't seem to be working. So I did manage to go through them all, though, and search them for terms. I've searched them all for protection and privileges term, and I've got all the petitions out of the whole collection that mention protections or privileges under all spellings, and I've put them to the side. And I know there's probably about at least 100 or so relevant petitions, some of them extremely useful. Um, so I could just kind of like, the thing is, what I want to, I'd like to know kind of like where we are with this subject as a, well, you're a university professor teaching students, right? And you're teaching them knowledge, right? Which obviously they're going to university to study. I'm studying, you put this facility up for everyone and anyone. It's not only for students, it's for the whole world, right? So the resource that you provided is for the whole world to use. So, I mean, so this book here, this is not the version that the lawyers have been using or that they put on the Parliament website. I think this version, I put the date somewhere, but this version has not even been out for that long, really. Or I think it was 2015. It might be off the top of my head. So this this section here on public petitions here, right, which basically confirms that public petitions are covered with privileges unless there is fraud or forgery. I really should have found this book by 2019, but in this book's the latest version, the most up to date version of this book, Jeremy Johnson KC cites the book in his Lord Hanningfield legal representation for Suffolk Crown Court, which I actually got a copy of that, and I'd read it and I understand it, and I didn't, if I'd have been a little bit more professional, I would have fine combed it and followed every single lead in the paper, every single legal case reference citation, and I would have chased up Sir Thomas Erskine May, but I didn't at the time. I just read the paper and got the basic principle of it. If I would have properly, thoroughly researched it, I would have got this little bit of information, which out of the entire book is literally extremely valuable, really, which I could have done with having that in 2019. I could have had, but I didn't have it in 2019. And you hadn't transcribed all those House of Lords petitions, and I don't think Brodie Waddle had finished his project. So I had actually been using political rights, and actually, I had been using them. I had a case with Parliament on the petition website, but actually investigation, not just. It was actually investigation, an inquiry, which I would put to the House of Commons. So I had to collect kind of like evidence to, substantiate and prove my claim. And I ended up in court because I ended up getting charges against me when I was out doing the investigation. And unlike Extinction Rebellion and Just Stop Oil, although Extinction Rebellion had only just kind of like surfaced in the national kind of like, Extinction Rebellion had just appeared and started doing actions and so forth around the time when I was kind of like went to court, and my kind of like little adventure was sort of finishing for what part of it that for that kind of period. So I actually, I was taking it on like proper seriously. I'm like, I am, I'm using, privileges. I'm using rights. I'm using protection because I've got a case. I've got a case to Parliament, right? So I actually made my lawyer claim exclusive rights, and I actually got a proper. Well, they call it a civil. It was in a magistrate's court in Leicester, but it was a civil hearing. I wasn't on trial. They did it separate. If I would have proved to the judge that I had privileges, then I wouldn't have faced a trial and been prosecuted. But I didn't have this. If I'd had this, then that would have been something. I still had full confidence and understood the general basis, but effectively, also I had my time taken away. I had like a few months to prepare, and then they took my time away down to 3 days. So I had like a fast one pulled on me, and I didn't have any legal representation. I had legal representation to obtain this special civil hearing, but after that, I did not. They wanted quite a lot of money, so I went in by myself, and I went in with quite a lot of material. If I'd have had your material, but your material didn't exist at that time because it was 2019 in the summer, towards the end of the summer. So, and I hadn't found this book. If I'd have been a little bit more professional, I would have found this book, and then that would have been, it would have I probably would have succeeded. But I went in, and then this judge, he was just like, he didn't even know what Parliament privileges were for MPs. The Crown Prosecution Service have got their own assisting offenders entire framework for granting immunities to offenders. If they want to use them themselves, they can grant them immunities. So there are other similar models in effect, which I could have pulled them up on, but I was a little bit kind of like, it's the reality of going into court, particularly a lot of these Extinction Rebellion cases and Just Stop Oil now, they've got loads and loads of people turning up to support them, and many, many people going into the court, and it changes the entire dynamics. I mean, they're being observed by the public. Magistrates' courts aren't usually court of record, so, when there were people in there taking notes and, and so forth, you've got backup, you're backed up. If you turn by yourself, they can just, literally rinse you off and rush through proceedings, or, don't let you speak properly or give you time to speak and all this and that. So basically, effectively, my judge, when I was speaking about the rights, he just, he just boomed across me basically that I was delusional and that no such thing existed, which couldn't be further from the truth. So that was pretty much that. Although I did complain against him later on, but I did actually get this. I had in my first hearing, I got this special procedure. The first judge did actually think that there was something in these rights. My first judge did think that there was sort of such rights, but then I got fobbed off with this other guy, Watson. So that was that. And then ever since, I've not kind of like, I knew that he was wrong. It's not like I just given up. I was like, this guy really clearly doesn't know what he's talking about, this judge. And ever since then, I've just been continuing my research and learning. But the thing is, that was kind of like the end of my part of my adventure, what was all around the country on site, actually doing something. I actually had an investigation into corrupt activities of the authorities. So I was actually, all these different petitions through history that we're researching, all these like caricatures, events, things that are happening through history. People are actually, they're about something. It's, these documents that we've got, these documents, these historical documents are actually documenting something, events, people's lives, issues, matters, whether it's, making rivers navigable and affecting trade and commerce, or people who are in prison who want to be released, or various grievances. So, why I ended up in the court, because I had a grievance that I was pursuing, and while I was out, investigating it, ended up getting charged against me. So, this is the thing. So, that's it. But then after that, you see, that was in Leicester. I'm in West Yorkshire. So I after that, they took my driving license off me. So I couldn't really, I was used to having the privilege of, free travel and movement around at my will, basically around the country. So, that was that. And then I got on probation, and but I left my job then, and then I actually got ill, and then I ended up getting out of probation, and then I actually was ill for so long on medical rights that I actually got my conviction overturned, but through medical rights, not through petition rights. So that's pretty much what happened to me. And then as it's all this protesting that's happening now has escalated since then. Everyone was in lockdown, and you were doing all the transcriptions. Dr. Brody Waddell's team were doing all the transcriptions and so forth. So, and that's pretty much that. I mean, that time has gone so quickly that I've hardly noticed it pass. I mean, that's 2019, 2020, 2022, 23, 24. So we've got like, a year and a bit, a year to 2 years with the lockdown period, and then these other 2 years. So, have I been studying? Yeah, I have, but I haven't had time to study all the time. And the thing is, if you're studying and learning about rights all the time, you're studying and learning about rights. If you're actually using the rights and doing something with them, you're actually doing something. So, you can't do everything at once. If you're pursuing a cause, then you're pursuing a cause, and that's what you're doing. So, but I have been, I've been putting some effort into studying, at intervals in between, and now I've pretty much caught up with it. And now I've got to the point of, going through all these transcribed petitions, which now it's clear that, privilege existed, even from Magna Carta way before even 1688, and then there's the 1661 Act and so forth. I've actually been putting lots of information together. I probably have got nowhere near as much information as you've got and that you're teaching your students, but I pretty much know where we are with it now. Now, the thing is, the reason why I've contacted you, this is not just to tell you my story. The reason that I've contacted you is that Um, so from 1661 onwards, people weren't just petitioning directly to Parliament or the House of Lords. From 1661 onwards, as you will know, um, the Public Act 13, Charles I, created this process by which if people were getting more than 20 signatures, then it had to go through the courts first. So this is kind of now what I'm focusing on. My curiosity is this. There are various archives at the National Archives. We've got archives here in West Yorkshire, in Wakefield and in Leeds, various different court records, Court of Civil Requests, Court of Sessions, Assizes records. There are lots of different court records. Now, the thing is, out of the petitions that you've transcribed, some of them have got, as you will know, over 20 signatures. Now, what I'm thinking is that I would like to know where the best place to look, if I'm going to do it myself, is to find some of the full court records, the dialogue from the courts, the court of record records or the orders. There are different records. There are, as you know, there are postillas, like records of orders. There are the actual dialogue from the recorder, or there are just notebooks of minute sessions and various different records. But I've actually got that full William Penn trial, and it's a really good version of it, and from 1670, and it's a beautiful and amazing piece of historical record. It's actually, got the full list of participants in the trial, and it's got all of the dialogue from in the courtroom, of what was said. And it's absolutely amazing and valuable. And to know that that is also a case which is brought under the 1661 Act, the Public Act 13, that's a charge, brought under the Public Act 13 for a tumult, because, they were gathering more than so many number of people in the street. But the dialogue of the court, they're very much quite sinister proceedings. They're not upholding or acknowledging their rights. They're saying they don't deserve rights, even they're threatening to put their mark on them. But you see, William Penn is quite knowledgeable in law, and he's referring to the Great Charter and rights and so forth. It's just the amount of information in the dialogue is very affirmative. So that piece from 1670, what I'm now interested in is finding other examples similar to the William Penn court record. But that's a charge against someone for a tumult. There's two. There's the Public Act 13, Charles I, has got two legal processes within that act. There's the charge if you contravene the act, like William Penn was accused of. That's a charge of prosecution. But also there is the legitimate lawful process of using the act to have your case put to Parliament, either of the Houses or the King, if you've got a large number of signatures. So that means that the cases that went to Parliament, that went through the courts and got consent to progress or proceed, there's got to be some records of those proceedings. I don't know whether it would have been Court of Civil Requests, or whether it's just classed under Court of Sessions or Assizes or whatever. It could even be possible that people might have just approached judges and got them to sign it. I've seen petition from Luton or Bedford for the road maintenance, where they've got constables or justices or people just signing the petition. If you need the consent of 3 justices, it doesn't necessarily say that it was had to be in court. They could have just approached them and got them to sign it or got consent. I'm not sure, but there must be some of the court records where they did have a court of record, and that's what I'm kind of interested in. What I would like to try and find on the records at the National Archives or in any of the local regional archives is evidence of people asking for permission in those court sessions to have their case referred to Parliament. And, if it was over 20 signatures or however many, because I would like to know something about the process. What was it? Did they have a name for it? What was it called? Was it just a court? Was it classed as a civil request, or what? To get the consent to go to Parliament. Is there dialogue? Were people bringing evidence in with them? Were they asking, for privileges, or if they were pursuing their case, were they saying, we've got any dialogue saying that, we need to show just cause? That's what they use. They say, I hereby show just cause, or I'm proving just cause, with evidence or whatever, or, that there might be some valuable dialogue which further substantiates people asking for acknowledgement of powers in order to pursue their cause, whether it's to show cause, find evidence, or apprehend persons or items or objects or so forth, anything like that. So having the William Penn full trial dialogue is itself quite valuable, but there must be more. There's that case of Henry Burton and John Baswick as well, when they got their ears chopped off. There is some. I found all that record. Those are well-researched cases. Those are quite popular cases because their wives petitioned John Pym at House of Commons for their release when they got released. But there's a lot of dialogue. There's all the dialogue from that. John Beswick and Henry Burton, they've got all the dialogue from those cases. So that's kind of like now what I'm interested in. And the thing is, I don't know how they've got the archives set up here in West Yorkshire at Wakefield. Then it's not all online. I've got to go in there, but it's quite local to me. What am I going to type in? I'm not a researcher. I'm not educated or learned as a researcher. So if I go in there, I don't really know where I'm looking or what I'm looking for. I've got an idea that, if I find the right records and the right court proceedings, whether it's quarter sessions, assizes, or court of civil requests, that if under the search term of the House of Commons or Lords or Parliament, then some cases might pop up, some records and archives might pop up, but people are trying to get a case progressed, forwarded, referred to Parliament. So that's kind of like because that is going to be very, very good information. It's going to be good, but where I am now with it is that what you've transcribed and what you've got down in your record is itself probably easily enough now to go with this. What Sir Thomas Erskine Mace, even the book that Parliament even used for the handbook, people definitely knew that they had privileges, and they knew that they were covered with privileges, and they knew that it was effectively based on pursuing a just cause. Like hue and cry, it effectively is almost, like they're showing just cause, but to the higher jurisdiction, almost like hue and cry in the local jurisdiction. I mean, I've read quite a few already. I haven't read all of them yet, but all of the references, that cover privileges. It's quite clear now, and therefore the 1688 Bill of Rights really. Once someone's read all your transcribed petitions from the House of Lords, it's very, very clear that the 1688 bill is only just a reaffirmation. And then now you know what Extinction Rebellion and Just Stop Oil are going on about Magna Carta, but I think they're kind of doing it wrong because the way I see it, this is where I am with it now, and this is like what I'm going to try and wrap this up with. My final point is to ask, right, where are we with this now? What is the official position on it? Because the thing is, no one's listening to me when I'm trying to speak to people about it. Extinction Rebellion and Just Stop Oil, they're going on and about this, the jury. None of them are saying we've got rights, we're claiming privileges. None of them. They're just going in there and they're having to put a plea in, and then they're having to defend themselves. But that's wrong. Oh, yeah, and by the way, I've missed out all this other bit. I've been studying the modern acts, the modern compatibilities, particularly like we've got control of advertisements, which is really important because it directly says that you can apply rights and privileges. No one's mentioning that act. It disqualifies quite a lot of activities from being criminal damage. It disqualifies a large number of activities from being criminal damage, and it quite clearly enshrines them in the installation and use of advertisements and installing them, and the state of them after, not being liable for any risk of danger or damage and so forth. Max Hill, the chief crown prosecutor, him and the police, they were completely ignoring this Town and Country Planning Act 2007, which pretty much covers you with privileges and immunities, and they're just pretending it doesn't exist, and it's not even getting into court. They're not even arguing what does and does not qualify for an advertisement, or whether they have got consent or not, or whether they are doing a political cause or not, or what class it is in materials. And now in the 2020 criminal procedure rules, which is only recently 2020, that's pretty much when you just finished or were doing your transcription, they brought in legally privileged items and information with other cases, which if you've got a case to the House of Commons and the client is the public, then all the petitioning material and all the words that you're speaking are legally privileged items and information under the criminal procedure rules. So there's a lot of modern stuff that obviously I've been putting my time into as well, not just the history part of it. Extinction Rebellion and Just Stop Oil at the moment, they're just not even trying. They're doing this jury thing, like, oh, we've got a right for conscience of a jury. But the thing is, the way I see it, this is how I understand it at the moment. How I understand it is this, right? You're not liable to the 100. You've got a case to Parliament, and they've repealed that 1661 Act, so it doesn't have to go through the court anymore. You don't need consent, right? So you're not liable. You've got a case under the jurisdiction of Parliament to Parliament when you got one, right? So you don't answer to the 100. You don't answer to any 100 or magistrates court or jury, because that's under a case brought to those courts or jurisdictions. So I don't know what they're doing in front of jury, because all of you've got cause for concern, which if you've got a petition and if you get people signing it, then you're showing just cause under oath and you're pursuing that. So, and if it's to Parliament, then it's not of the concern of any local 100 or jurisdiction or local jury. And that's the point, that's where I am with it. Now, I know that you know a lot more than what I've been learning and reading and studying, although I don't necessarily know if you've been putting much time into the modern law, but I've been going through quite a lot of acts and figuring out the whole compatibility, and all of them are compatible. Some of these MPs and ministers do know about the law and the rights and the compatibility because it still is compatible and it's been made that way. But they're just when you get into court, none of them are. They. I know that DJ Watson, either he was an imbecile or he just didn't have a clue what he was talking about, and I think it's a little bit of both. You know, but it's still happening now. But I don't see any of these. A lot of the King's Council lawyers at the moment, they don't even know about the control of advertisements law. They're not trained in it. They don't know about it. Mainly local councils use it, but when it's defacement or surface damage or anything like that, there's fines for it, whether you've got consent or not. It's not even getting argued or debated. They're just leaving out a massive section of law, and all these public civil rights lawyers, even King's Counsel, they're not even on the right page, which is what I'm getting annoyed at now. And I've got so many complaints with Judicial Conduct Investigation and the Crown Prosecution Service. And now that I've got your petitions and found some time to go through them all, it's like you've been watching the news and following Facebook and the newspaper a little bit. You're in London. You're not like burying your head in the ground like an emu. I mean, you know exactly what's going on. So this is now why I am saying, and I'm not asking professional advice here. I don't, I'm just like, a person. You've got the resource for everyone, right? So it's not login only. It's not access for students only. So I'm entitled to make contact to the creators and publishers of the resource, which is there for everyone, and speak about it through that approach, not through a kind of like, I'm not getting a lot of responses from, whenever I email universities or professors, there are a few who respond, like Karen Bowie never bothered responding. I don't know whether it's this new culture that they're saying that a lot of the academic community have, like Obama now is, Obama has been over at Stanford and Harvard giving speeches and trying to persuade American students that, the Constitution's rubbish or no good and they need to scrap it and things like that. So, this whole they're saying that the whole education sector might have kind of been kind of slowly groomed, and setting a certain attitude. So I don't kind of know, but Brody did reply to me. I think Brody's the only academic that has actually replied to me. He did speak to me. Like, he didn't completely and totally ignore me. So that was like something. So what I'm thinking at the moment is, I don't know how to turn up at the National. Well, I can't get to National Archives at Kew Gardens. I can get to the ones at the local ones here, but I'm not too sure, how to, get stuck into get my head into the right volumes and archives and start getting the terms in. But I've got a good idea of what search terms to use. I'd really, really like to get some of these dialogues out of the court records, like the John Baswick and Henry Burton dialogues and the William Penn dialogues, but for some of the other cases, maybe someone has been through them all. You get that impression. It's suggestive that the William Penn trial was always a popular one. It's a good subject study because it's got quite a lot of interesting convergence of it's a very, very unique convergence of events and situations. They were accused of having a getting more than 20 people together in the street, which under Magna Carta would have been lawful and protected, but because this 1661 Act made it illegal, they were in court. Then the jury said that they weren't petitioning in the street. The thing is, under Magna Carta, if you are officially petitioning, then you're protected, right? But because they were officially petitioning with too many people, then it was an offence. But then the jury said, well, they're not even petitioning in the street, they're just standing there talking. So then it's not an offence because the jury didn't think they even were petitioning. And then you've got all this dialogue that, they're ignoring their rights, they're quite sinister in there, are the justices and the recorder. And then you've got the knowledge, William Penny's, talking about his dad is like his dad is a captain on a ship. So, he's quite educated and he knows about, the Great Charter and so forth and rights. The William Penn is an amazing record of court proceedings, and the John Bastwick and Henry Burton ones as well. So, are the other records that exist? Has anyone even bothered to go through them all? And is there anything in there that's not worth pulling out or looking at? Because, the William Penn one was the, almost like the diamond in there that covers pretty much all relevant topics in one case. It's a good convergence of issues together. Are the other records that exist quite mundane and boring? Obviously not, looking at your transcribed House of Lords cases. So but the other thing that I wanted to say is this, right? And this is that if the 1661 Act was repealed in 1986, so the Public Order Act, and that's around the time the Crown Prosecution Service were formed properly, they've not really encountered the Tumultuous Petitioning Act or petitioning the Crown Prosecution Service, because no one's been through the courts with petitions anymore, and they didn't need to. It was straight to Parliament. But the thing is, prior to the Crown Prosecution Service, the police just used to hire their own lawyers, right? Barristers. Now, the thing is, what I'm thinking is that up to 1986, let's say, all through kind of like, the 1920s, the 1930s, the 1940s, the 1950s, the 1960s, they've still got the Tumultuous Petitioning Act was still in force. And what about all the miners' strikes and political actions then? I mean, they were getting a hell of a lot of people, but I don't think they were getting permission or consent through the courts. Now, what I'm interested in is more kind of like modern petitions to Parliament between, say, 1920 and 1980, right? Were people speaking about or using privileges then, or didn't people really talk about it? And what about all the petitions between, say, like the 1920s and the 1980s that had more than, say, 20 signatures? So someone's got to have got over 20 signatures on a petition while that Tumultuous Petitioning Act was still in force. What court did they go to get consent? I mean, if we're talking like 1920s to 1980s, this is kind of like very modern, and you're gonna have like let me try and think of the word, pamphlets or forms to fill in. Like if you go to court now, right? You can go online and you can go to the court. You can go to the small claims court online and you just fill it in. You can do your claim online, right? If you want to, the public don't usually, people like, you and me or whatever, the public, we don't prosecute criminally. The police deal with it. The police fill all the forms in. The police do the affidavits. The police put it through to the CPS. They do all of the legal process is done for you, right? We don't really touch it other than, writing a statement or whatever. But for a civil case, you can get forms. People bring civil cases themselves. They don't always get a lawyer to do it. They fill the forms in and make a submission to a county court or whatever. So I'm thinking, where are all the, like, in 1920 or 1925, what happens if you want to petition Parliament? You got the 1661 Act. What if there's like 80 people signing? What about, football stadiums and all kinds of things like that? Where were they? Surely, when you go to court or you want to go to the county court or whatever it is, I think they still had, in 1920s, they still had assizes, didn't they? So they had assizes and maybe even quarter sessions still. What were they? Where are all the more early modern? Where are these, like, court forms that you fill in? Specimens. I mean, it's like your driving license. You got a specimen of a driving license going all the way back. I've got some on the table over here. 1960s driving license or 1950s driving license. It's a document. What about the standard court forms? When you go to the assizes in 1920, we're not talking like, these aren't exceptionally rare National Archives, get the white gloves on sort of documents. It's a piece of paper from the 1600s. It's exceptionally rare archive document. You can go on eBay and there are like 1920s, 1930s, 1940s, all these papers. You can get election material from the 1920s, 1930s, 1940s. Where are there's got to have been some sort of instructions, directions, something that tells the public that they can apply to go to court to get consent for a petition to Parliament, because you've got, over 20, if you've got 100 people signing, you've got to get consent. Did you just fill the standard Court of Civil Requests form in, or what? Now, what I'm starting to think, now you will probably know a lot more than me about this, but I don't know how much you've got into the court side of it, like just courts, because you're looking at like you're sort of looking at Oliver Cromwell's letters and notes and speeches and all these different things. I don't know how much you've focused on court history, right? There might be historians out there who are just specialists in courts, the history of courts, right? So what I'm thinking, like, the thing is this: there's something. There's some kind of I know in that tumultuous act it said you had to go to the assizes or the quarter sessions or just get 3 justices. But the thing is that in the William Penn case, right, in 1670, notice that at that point in 1670, when we've got the tumultuous petitioning act, right, at that point, it had been around for quite a few years, right? When Penn is in court in London, he's in front of the mayor with the aldermen and the recorder. There's no solicitor recorded as being present, as far as I know. I think there were 2 constables or something in there, but there is no solicitors as far as I know. They're in front of the mayor, right? Well, the mayor used to have a commission like magistrates or judges. The thing with a mayor is usually head of a council. Now they're only mainly ceremonial position. They walk around like a town crier with the robes on, usually if there's an opening or ceremony. They don't have a proper place on most councils in the cabinet. Like, you have your elected councillors with the heads of the council, who are the chairman and the cabinet of the council, right? Now, this is something that I want to, not a lot of people are thinking about at the moment, right? Your alderman, the alderman, right, are almost kind of like councillors in a way. The thing is that there is a division at some point between courts and council, because at the time of 1670, William Penn, you've got the mayor, who is normally the head of the council, is hearing a criminal case, right? Now the thing is, if William Penn would have gone through the proper process and procedure to get consent to, petition about whatever religious matter to Parliament with over so many people, then he might have even been in front of that mayor asking consent, the same guy who was trying him for the crime. And they would have got consent, and they would have officially acknowledged that they were doing it and got consent permission. So that mayor would have known that he had rights and privileges, right? But because they didn't get consent, they were in front of them, and he was saying that he didn't have any rights or privileges, or they didn't even deserve any. So it's ironic. But the thing is this, right? This is the thing. In the William Penn case, in some London courts, they've got randomly chosen jurors. They did have a process where jurors were chosen randomly, right? Randomly selected like they are now from the electoral register. But some jurisdictions and some commissions and some courts, particularly going back before 1670, as we know, had permanent jurats, permanent jurors for life. They were elected. So they had elected jurors, because some of the jurors' oaths, I found that they had to know all of these rights and privileges. They had to know them already. They already knew them. They had to know them. They didn't have the solicitor or the barrister tell them it. They had to know it already. Like it was a certain amount of law that they had to know to do the job, right? Now, the thing is, with those permanent jurats, the permanent jurors, right, I'm starting to think that they're very much like councillors if they're permanent, because councillors, right, go in the chamber and they vote, but they're meant to vote on what the electors want. They're meant to represent the electors, but they're permanent and they vote. They vote in the chamber, right, in front of the cabinet on things. Now, the thing is, councils now deal with civil requests, like, can I, change the usage of my land or building, or can I expand or build on my building, right? This is civil requests. You put a case to the council, you've got to make a case, right? And people can oppose it. Now, this is the thing. Currently, in the criminal procedure rules and civil procedure rules, we don't there's no they don't seem to know anything about petitioning or petitions, right? And there's nothing about petitions or petitioning in the civil or criminal procedure rules, as far as I know, I've searched, right? The only time when the word petition comes up, really, is if you're getting divorced, because they still call it a petition for divorce, right? You don't get married in a court, though. You get married in a church. And then, but when you get divorced, then you go to a judge, right? It's still showing judicial powers of clergy, right? But they don't deal with separations. Now, because, to do with your, you either a legal entity, and then you're not a legal entity anymore if you separate, right? But the thing is this. In the council procedure, in the local authority, the local council procedures, They do have a time slot, an allotment allotted to hear petitions, right? Now, if you think about it, in the local council, um, you've got all these civil requests and different business, different cases being made for this and cases being made for that, and all these. You're hearing cases. That's what they're doing in the local council, and the councillors are voting on them, supposedly on behalf of for the public, right? Now, the thing is, you've got local matters, but if you want to object to it or raise it higher, or if you've got any other matter, it needs to go to Parliament. The thing with the local council is they've got the mace in the chamber, right? And it's still like the mace in the chamber in the Commons. So surely, you're raising a matter from a local level to Parliament, which is why, all this judicial review only scrutinises process. You're not appealing something. And I've been arguing with the Petitions Committee that really any local council decision or planning application that's approved by a local council, you can really appeal it to the House of Commons, to Parliament, right? But how would you do that? Well, by petitioning them. Well, who refers the petition, or how do you do it? Well, you've got a slot in the council procedure for petitions. You can show a petition about any of the planning applications, but it's not just you can oppose it anyway as an opposition to that case, or you can show petitions. But if you're already opposing it anyway, what's the point in the petition? This is the thing. What happens if you want to appeal it? Well, you'd appeal it to Parliament by petition, wouldn't you? This is the thing. And if you were getting consent, right, you would need consent from the council to appeal their decision to Parliament. Because if the council say, right, we're going to build a block of flats, right, and they've already made the order and you objected to it, but you lost, you might want to appeal it. But they'd have to hear the petition, wouldn't they? And what if you got 100 people to sign it, it was over 20 before 1984, then you'd have to get consent to appeal it. Well, who would you get consent from? Well, I would have thought the mayor in the council, the mayor, the head of the council chamber, the councillors, surely, because that's the chamber that made the order. You want to appeal it, right? So surely you would be getting consent from the council chamber in the time allotted to hear petitions. Surely. So it won't be anything to do with the criminal court or the county court, although they didn't have them in the form that we have now. It was just the assizes and quarter sessions. Quarter sessions is 4 times a year. Assizes used to be 2 times a year and then got more frequent till it was 4 times. So the King's Justices. But this is the thing. That's the irony. The mayor is... What is the mayor in William Penn? He's council, isn't it? He's the mayor, but he's hearing a criminal case. So that is a mind bender. So this is the thing, as far as it says according to that 1661 Act, all you need is 3 justices to get consent, or a larger part of a grand jury. Well, when do the grand jury, it says or. Well, surely you could go into a court and get a clerk or whatever to get a judge to sign it or approve something. You might not even need to actually have a proper hearing. You could just give it to the court clerk and you say, I need 3 justices to sign this, right? Or if you want a jury, whatever. But they got rid of the juries. If you look at the timeline of the courts, they started to get rid of the civil juries around the mid-1800s, and then you don't have them in the magistrates' court. So you wouldn't have been able to have it in front of a jury. So, it's... Why would you want... If you went, you just need to get hold of a judge to approve it, really. Why would you have a case against you? You wouldn't have, and this is the thing, if it's under 20 signatures, you don't even need to get consent from from any of them. If it's under 20 signatures, you don't even need you never even needed consent. You can go straight to Parliament. But obviously, if you've got more signatures, it's more substantial. So what I'm trying to say is, what about this that tumultuous act? What, there was a process in place to get consent, right? Now, were people using it in 1920, in the 1930s, all through the 1940s and 1950s? Were people using it still? And at that time, there's a hell of a lot of things being printed. At that time, governments, councils did have brochures, pamphlets, leaflets, all these things, like, early Coca-Cola signs, all these period things, but not like, we're not talking like ancient scraps of paper, from the 1700s or handwritten things. We're talking about printed things. I think that there's got to be some kind of maybe direction or instruction, or even a form, or like like when you go on the government website now, if you want to claim your tax back, you go on the government website, it tells you how to do it. Are there some pamphlets or something? Where is all the records of paraphernalia, court leaflets, flyers, pamphlets, not just, sessions, postiers, notebooks, hour book, minute books, How about, like, in the 1920s, people knew you could petition Parliament, but people knew that you had to get consent if it was like, an entire rugby team or something or whatever. I mean, where, if you go into a court, right, they've got, paperwork, they've got things in the foyer in the court, like, a stack of papers, fill this form in, fill that form in, fill the other form in. Not just like, right, I've got a petition, I've written the petition out, right? Because unless you just went in there but the thing is, you can't collect the signatures until you've got consent, can you? You won't go in there with a petition with 100 signatures on and say, can I have permission to go to Parliament? Because you're not allowed to get the 100 signatures on it, right? Or you can have it drafted out and written without anyone signing it. You draft it, right? It's prepared, right? But there's no one else has signed it yet. So the person who's created it has drafted it, right? Then you go into the court and you say, right, get 3 justices to sign this. Surely you're going to have to book a session if it's the grand jury, right? It's there's got to be some more early modern material somewhere, what is a proper process. And if it is, right, this is where I am with it now, right? Why aren't the courts even acknowledging that any process exists? Now, you don't have to use it anymore, but at least when they were using it, they acknowledged that it existed. And if it exists, then there are rights that come along with it. There are privileges that come along with it, and so forth. Were acknowledged. Once they say you're officially doing it, you're doing it now. This is the thing. You go on Parliament website. You don't need consent from the courts. You publish a petition on HM government website, and you can share it. You're aware. You're collecting signatures. You can share it online, print it out, go around the streets, print adverts for it. You're doing it. But the thing is, people are getting challenged in court now. People are getting a little bit carried away with their advertising, like Gail Bradbrook smashing windows or whatever. And they're getting charged with criminal charges, like William Penn. But they're not. No one in these courts are acknowledging that those are persons have an official case to Parliament which has rights or whatsoever, and using the other laws or so forth or anything. I did. I claimed it, and I nearly proved it if I hadn't have had like a buffoon judge who didn't know what he was talking about. If I'd have had this book, he would not have been able to say that it was a figment. And if I'd have had your petitions transcribed, he definitely wouldn't have been able to say there's no such thing as privileges, right? So the only thing missing now really is some more of these court records. But I don't think that it just needs to be like after 1661, through the 1700s, court of records like the William Penn kind of like documents, the full dialogue documents. I'm thinking like, there's got to be some 1920s, 1930s, 1940s, 1950s. There's got to be some piece of paper that says, apply for consent to petition Parliament or something, fill this form in, whatever, or get a hearing. Or did you just, I don't know how they did the assizes or quarter sessions. Did you just it was on a certain date and you just had to go there on that date and sit and wait to be seen, and you didn't really fill anything in? I don't really know how they ran the assizes. This is the thing. Did you just turn, it's 4 times a year, you go, you turn up, and you sit in the waiting room and then they call you in and, there was certain listed cases, but then they've also got slots to hear petitions like the council. The council have got they've got a certain slot thing to hear petitions. But this is the thing. There's something about the local council. It's this mysterious division between the council, and this is the irony of the mayor in the William Penn case. This is the irony of the mayor. The irony of him. Sam Starling. Sounds like Starman, doesn't it? Sam Starling. The irony of Sam Starling, the mayor, because he's giving consent for petitions and he's also prosecuting for people for not getting consents as well. And he's got a jury in there, and the jury can also give consents to go to Parliament as well. And why is it now, although we don't have the Tumultuous Petitioning Act anymore, and it seems to be around the time the Crown Prosecution Service came into being, funnily enough, now they don't know anything about petitioning in courts. They're not even acknowledging them. But yet before that, it clearly existed and a special process. But at that time with the quarter sessions and assizes and the council, the mayor was able to give consent because the mayor was a judge, had a judge position. And I don't know whether those aldermen also could qualify. Not just these, not just the King's justices going around. So so this is the thing. I mean, so the thing is, where are you with your current position? Knowing that at the moment there are loads of people going through the courts and they don't seem to be doing it properly. You're just doing your own job, which is teaching people history. I am, literally getting annoyed with the fact that I'm trying to help people and they're not listening. I don't understand. Where are we with this now as a country, a nation? And the fact that we've made a hell of a lot of progress since 2019 now, or you have helped us progress. What is happening with the Attorney General's office as well, because he's meant to be dealing with contempt, and surely it's contempt of court if you're a victim of an unlawful act. So, I'm not really asking you, I don't need legal advice. I just want to know, basically, we need to come to some kind of general consensus of where we are with it. Some kind of like official kind of, we need an official national position on this, what everyone can sort of agree to. And that's kind of where I am with it, and that's kind of what I wanted to say. But I was wondering if any of your students who are looking for a job, like some students get part-time work in cafes or in pubs or on a weekend on a Saturday or Sunday. I was kind of wondering, like, would any of your students be interested in, like, if I paid them some money instead of working in a cafe or a pub on a weekend? I wouldn't mind getting some help starting to go through those records to try and find the things that I've been talking about, like the court of record dialogue of more proceedings of people getting consent to forward to Parliament, or any of the other paraphernalia from the more modern period that the Tumultuous Act might have used through the courts, like forms to fill in or pamphlets or promotional material telling people how to apply for consent to petition Parliament through the courts. So, that's kind of what I think that's the final area of law to look into now that all their actual petitions are transcribed. But I mean, they pretty much might say enough, but it's just trying to convince the courts now, because they don't seem to be coming round to the idea.